Turn to the fourth case on this morning's docket. Case number 108930, State of Kansas v. Vrabel.
May it please the court, my name is John Bortnick, and I would request 3 minutes for rebuttal.
3 minutes is granted.
The issue that I would like to start off and have the court focus on, and that I feel is most important, is the same issue that Judge Malone, in his opinion in the Court of Appeals, set forth and requested guidance on, specifically when there is a violation of KSA 22-2401A, is the appropriate remedy suppression of evidence. And in this case, when there's a violation of that statute dealing with territorial jurisdiction of where officers are allowed to exercise their police powers, and they conduct, such as Prairie Village Police did, a controlled buy with the use of funds, wires, things that ordinary citizens don't do in the neighboring jurisdiction of Leawood. Should that evidence be allowed? And the brief, which I was fortunate to have received from the amicus brief, sets forth what authority this court has to say, no, if you don't follow the law, police officers, this shouldn't come into evidence, because we all should follow the law. And the Bill of Rights is one area where this court could say, hey, look, I believe that an unreasonable search occurs when it is unlawful. That could be one grounds. I also believe KSA 223216, as set forth in the amicus brief, says if there's an unlawful search or seizure, then you can suppress. Then of course, there's the inherent supervisory authority of the court, which I would ask that be exercised in this case, so that police officers know that when there's a law, which they know in this case, this is a law that's on the books, it's been well litigated, such as Sodders, that they can't have an agreement in violation of that law to continually violate it and then be allowed to submit that evidence in court. And for those reasons, I feel that this court has to step in and say, we all have to follow the law. You can imagine in these two cities that adjoin, if you own the grocery store and you have police officers from Prairie Village that aren't in your jurisdiction setting up drug buys in your parking lot, who do you go to complain to? Say, I don't want my customers walking by and seeing you guys doing these, because you have to go to Leawood. But the Prairie Village police are the ones that are doing it. And I think the whole reason the law is set forth is so that these officers are accountable to their individual jurisdictions, the one that pay them, the one that tell them what to do. And therefore, this law, it needs to be enforced. The majority opinion takes the position that this is a exception under 22-2401, in that it was a request for an assistance. And that seems to be a way of getting around this statute's language, its plain meaning. And if you look at it, from square one, the statute contemplates that it can be an agreement oral, it can be an implied, agreed. But the requesting jurisdiction is where it's supposed to happen. In this case, it's Leawood. Leawood here requests nothing. Leawood is called and said, can we use your property to conduct this by the Prairie Village officers? So they're really not, and to me, assist means help. What is Prairie Village? How are they helping Leawood? They're just simply using their property. So it takes the meaning, the plain meaning out of these words as a method to get around what was contemplated by the statute. So in that respect, I think it fails. I think Judge Maloney, in his opinion, agrees that that's not what's contemplated here. And for those reasons, similarly, I think the state is urging that this doesn't amount to an exercise of police. I think the statute police authority, or they're not exercising their powers specifically as police officers.
Are you saying that an outside jurisdiction can't initiate the contact? It has to be the jurisdiction where the property is in order to request for assistance?
No.
Are you going? I
No.
thought that's what you just said.
Well, if I said that, I misspoke. What I'm thinking is, it doesn't matter who initiates the contact,
Okay.
but there has to be a need for assistance, help. And in this case, it seems to me that this is just whether whoever called, but you can imagine this scenario, Leewood's not going to call and say, hey, can you help me by coming over and staging a drug buy here? But the statute to me says the requesting jurisdiction, where it happens, Leewood. I mean, if you look at Sodders, I think, and Sodders seems to support this theory that, look, police can't stand by. And while I think it was Lennox, I'm not sure, they come in and execute a warrant, or another jurisdiction, I can't remember. They said that's in violation of this statute, but at least arguably there, you could say, well, they're helping because the property was in the requesting jurisdiction. The police here they could set up this controlled buy wherever they wanted to. So I just don't think it's help. I think it's, hey, we're going to use your property. And is that okay with you?
Can you focus on Chief Judge Malone's concurring opinion where he drops off and says that the appropriate remedy here is not suppression of the evidence?
Yes.
So let's assume we've got a violation of this statute.
Okay.
Convince me that suppression is the appropriate remedy.
Well, the reason that I believe suppression is the appropriate remedy, and Justice Malone seems to talk about federal cases, and specifically there's, I think it's Green. This court, as opposed to a federal court, has the right to say, this is how we interpret our Bill of Rights and our Constitution. There's ample case law set forth in that amicus brief that this court can interpret their Constitution more restrictively than the federal court would. That's one reason. And I think the reason it should be done is because if you don't do this, and there's two other methods, if you don't do this, this law becomes absolutely meaningless. And then any police officer can do whatever they want in any jurisdiction. It's that simple. Because there is no penalty for violating this law. And, you know, you look at it, the state's saying, well, if there is a violation of the law, we don't think it amounted to a constitutional violation, so go ahead and do it. Someone has to say, look, you're not going to be able to use evidence that's gathered illegally. We're not going to stand for that. And that's what this court, we all have to follow the law.
I'm not sure I'm understanding your argument, so if you could help me. Are you suggesting that we need to find that this violation of the law violated the Constitution before we suppress?
No, I'm saying you could. You could. Because, I don't know which Constitution you're talking about.
The Kansas Constitution.
Okay.
Because you ask us to interpret our Constitution
differently. I would say please interpret your Constitution to say, regardless if this is a Fourth Amendment, this violates our Kansas Bill of Rights, and we can interpret our Bill of Rights the way we want. This is an unlawful search, therefore, in my opinion, it's unreasonable. And the Kansas Bill of Rights says an unreasonable search is what we're avoiding. And also, I think, as the court did in Sodders, there's supervisory authority, which they can exercise and say, we don't like this. So, yes, I am asking you to say the Bill of Rights, if you see fit. That's one mechanism, as the amicus brief set forth, where you could exercise your authority and suppress.
But you would recognize that there could be non-constitutional grounds for suppression. Are you asking for that
yes,
as well?
I'm saying there's
So
both. Is that, like that federal wiretap case that's set forth in the amicus brief, they said, well, this may not even be a Fourth Amendment violation, but we're going to suppress this. My point is, this court has different mechanisms by which they could say, we're going to exclude this. And they've done it before in Sodders. And that's what I'm urging them to do, is uphold the law. I have nothing further at this point unless there's questions.
Any more questions? Thank you, counsel.
May it please the court, Sean Minahan, Assistant District Attorney for the Johnson County District Attorney's Office for the state.
Good morning, counsel.
Morning.
If Fourth Amendment isn't violated, just a state statutory provision by the police, what's the remedy if not exclusion of the evidence?
You know, sometimes there isn't a remedy.
Then what's the point
Well,
of any kind of jurisdictional limitations on police forces?
well, I would point out that even in an illegal arrest, there isn't really a remedy, and that's a constitutional violation. I mean, the remedy, I suppose, would be you release him and then you rearrest him, and so there's not remedies.
There's a pointless remedy,
Yeah,
but there is a remedy.
a pointless one. Yeah.
Right. So that's distinct. I mean, here there would be no remedy, would there? I mean, can you suggest any other remedy other than exclusion of the evidence here?
Well, I think that in this specific case, if you said, well, there's no remedy in this case because there's no indication that the police acted in bad faith, you know, in this case, the defendant wasn't prejudiced by this. There's no real prejudice where the defendant is CI by, and the Mr. Vrabel's attorney keeps on talking about this search. There's no search in this case.
No.
Where the CI by took place by one police force versus another. There's no injury to him. But, you know, and I would say that if this court came down and said, yeah, you can't do that, you know, that the police are there to uphold the law and they'll follow the law. But if the police continue to violate this, I think that you have a remedy to start suppressing where you have bad faith.
Mr. Vrabel's out of luck, but the next guy gets the break.
Well,
I'm asking about him.
Yeah, I don't think that...
That's the best you have, though, is that you maybe let them get away with it a time or two, and then if they keep doing it, we lower the boom.
I don't think that's just all. I mean, I think that that's a good remedy.
I'm asking you for anything else.
No, I think that that's... there's no
That would
other...
be the definition of all. Okay, thanks.
Yeah.
If these officers did not have legal authority to conduct a controlled buy in the county in which it was done, would the CI be a state actor? And if not, why wasn't the CI prosecuted? And in that regard, why weren't the officers prosecuted for aiding and abetting by providing the money for a drug transaction if they were not acting in their official capacity?
Well, you're cutting off all my corners, Your Honor. No, I think that he acted as an actor for the state.
Well, how can that be if they had no authority to do the buy in the place they were, and we have some case law that says, oh, well, that's okay, they can make an arrest as a private citizen, but as a private citizen, they can't violate the law, can they?
Well, first of all, I don't think that there's any intent on the part of the police to actually distribute. I mean, they're investigating a crime. Second,
but they gave the money to make the buy.
Yeah, any actions that the police took were taken in Prairie Village, not Leawood. They simply witnessed the interaction in Leawood. And also, I don't know a prosecutor in the state that would prosecute a police force or a CI like that.
I understand, but what the point is that jurisdiction does make a difference because it provides the authority by which these persons can do such things as buy drugs.
Yeah, nobody's debating that jurisdiction isn't important. I don't think either side. I don't think the Mr. Vrabel is, and I don't think the state is. My point in my
But you're just saying it's not important enough to provide any remedy for its violation.
no, I'm not saying it's not important. I just don't think that there's a remedy for him. I mean, what injury did he sustain, Your Honor? You know, he didn't sustain any injury in this case. I do want to point out, before I run, I guess I have plenty of time. This is an interpretation of 22-2401A. This court has to, has a duty to construe this in a reasonable manner. And the operative language in the statute is, what does it mean that officers are exercising their powers as law enforcement officers? Well, it must mean something more than just what a citizen has. It's powers that they're imposing on other people. Well, what powers does an officer have? An officer has a power to arrest, to seize items, to seize a person, to search items, search a person. Those are things that a common citizen doesn't have a right to do legally. And I think that that's the meaning behind this entire statute. And if you look at the two examples of police power in the statute, they're related to search and seizure issues, specifically seizure and arrest issues. KSA 22-2401A 2B, which is the section on municipalities, officers in municipalities, it's fresh pursuit. Well, what's fresh pursuit? Is entering some building. The classic case is you're chasing somebody, they run into a private building, or a house or something. You can follow them in, even though you're intruding. That's a search and seizure issue. The second example that they use of the power of police, 22-2401A7, arrest, where the police can arrest even for a traffic infraction. We know that common citizens can commit.
That they observe.
And
And you just told me that they did all of their actions in Prairie Village.
But they didn't arrest. They didn't arrest him in Prairie Village or in Leawood. He wasn't arrested until 7 months later, I think. I think this happened in July, and he was arrested in March.
But they took action before they viewed a crime if they took all their action when they were in Prairie Village because the crime hadn't occurred yet.
They didn't take any action in Prairie Village except for witnessing.
You just told me they did. They
No,
provided the money and they did all of that kind of stuff.
Yeah, I'm sorry. I misspoke. Yeah, they took action in Prairie Village, but the only thing they did in Leawood, the others, the city where they weren't law enforcement officers, is view a crime being committed.
Didn't they also authorize a private citizen to do what would otherwise be an illegal act?
Right.
And the
And that occurred in Leawood.
And the only way that could have occurred is through the authority of the police.
Right.
Isn't that true?
Right.
So they did extend their authority to Leawood.
If you want to look at it that way, I think that I think that our best argument is that this isn't a police action that's covered by this.
Wait, say
Finish that
again?
sentence.
I think the best argument is that this isn't an exercise of the powers of the police. I mean, a common citizen could set up a drug buy like that, contact the police in Prairie Village, Leawood, and say, hey, this guy wants to sell me drugs. I want to do it. And they could do that, and they could charge that person. And so...
But when they're authorizing that to occur,
Right.
they've just been informed that crime is going to be committed, correct?
Right.
And the police are allowing that to happen through the private citizen setting up the buy.
Right.
Under subsection 2, are they not exercising their powers as law enforcement officers by allowing that crime to proceed?
Well, I don't think that that's what the statute was intended for. I think statute was intended to deal with the interactions in search and seizure issues, specifically seizure and arrest issues. And I think that's evident by the two examples that they give in the statute. I would point out, and I want to make a distinction, or maybe I don't want to say that. I think I want to kind of point out what the logical end to the Mr. Vrabel's argument. If Mr. Vrabel wins, and it's maybe something that this court would want to
Then they'd have
delineate.
to go to a parking lot that was in Prairie Village. That's the whole thing. All they had to do was set this thing up and conduct the buy in a parking lot in their own jurisdiction.
Right. Well,
that's the only difference. Is just made it more convenient for them to have a road that was convenient for the
Right.
drug dealer.
Well, can you imagine a CI saying, "Hey, but I really need to do this in Leawood, or I really need to do this in Prairie Village."
Okay, so then
You
what's
know?
your best argument for this as a request for assistance, and why couldn't they have done that?
They called, and first of all they had.
What is the Court of Appeals found that this was fit the exception request for assistance,
Right.
and what's your best
They
argument
have
for that?
I'm sorry, Your Honor.
Go ahead.
They have an agreement between the different municipalities in Johnson County to where you can do drug buys like this, and you contact them. And certainly Leawood, if they didn't want this to happen in their county, they could have said no. And that's the reason behind the statute is for the police in that municipality to control what happens in there.
Right.
And they have the ability to say no. You can't do it here, but they.
The assistance is the granting of a permission to let it happen in their city. Is that
Right.
what you're saying?
What it is?
Yes, and I would point out that crimes don't have borders. You can't look at these things. Well, these are Prairie Village crimes, and these are Leawood crimes. Drug trafficking and drug distribution.
Isn't that a legislative matter? Because the legislature knows how to do it. They've granted the Kansas Highway Patrol authority to act anywhere within the state. They have not granted that same authority to city officers.
Yeah,
And there's a policy reason behind that, because if the city wants to control who is enforcing the law within its borders, then it can do so. So there is a legitimate policy reason behind that
but
statute.
But there's you have to reasonably construe the statute, and so you should be thinking about these things. I want to put before
Can
run
I
out
ask,
of.
is what you were saying that the request for assistance was a quid pro quo kind of thing?
Yes.
Like I'll scratch your back this time if you scratch my back when I call you and want to do the buy in Prairie Village. Is that the request for assistance? I'm still not sure I understand what the request for assistance
there's
is.
just an to say that each of these municipalities do these drug investigations in a vacuum isn't accurate. I mean, these people work together. They all know each other. They get together and talk. And so this is more of a group action in Johnson County than it is some individualized system, And so, go ahead.
I was going to say, I understood you to answer my question earlier that the mere granting of permission by Leawood PD to allow Prairie Village PD into their city to do this buy, that was sufficient to be a request for assistance.
Right.
And that was granted.
Right.
That's the assistance, okay.
A factual question, is there anything on the record that establishes that there was a communication that clearly said you can come? Or was it just calls were placed, but nobody had it, but the Leawood officer knew the log said there were calls made, but was there any evidence that they actually had a conversation about it?
I think that, both of them testified. The person that was called in Washington, who was the Prairie Village officer, and the Leawood, I don't know if I think he was, what did they call him? Like not the dispatch, but like the sergeant in charge or whatever. Both testified at the suppression hearings. And I think that he had said that he called and they notified him that this was going to go down. Then the next day before it went down, they called again and said, hey, this is going to go down. And then they called him a third time after it had happened to let him know everything went okay. It's
That
going
was
down.
the one that wasn't they didn't actually succeed in talking to each other. I think it was a third of the
Okay.
three.
Okay.
You started to say you want to talk about the logical end of your opponent's argument.
Yes.
And we interrupted you. Is that where you're trying to?
Yes, thank you, Your Honor.
Okay.
This is my concern. If this is, my concern is that the argument is that, well, anytime a police officer is on duty, he's acting, exercising his police duties. And so if an officer if an officer in Johnson County wants to go to Seward County in Liberal to take pictures of a stolen vehicle that was stolen in Johnson County, or interview a witness, or even transport a defendant from jail there to Johnson County, he's acting in his capacity as a police officer. Does he have to call every county between Johnson County and Seward and say, hey, would you drive me through your county, drop me off so the next county can, and then do they say, well, we don't want to do that, you can do it? Or the logical end, they can't even do that. They're arguing that they have to ask for assistance. So somehow through ESP, these various counties will have to know that Johnson County wants to drive to Seward to pick up to take pictures in a criminal investigation, and then call him and say, hey, will you do this? I mean, it's just logically absurd. And this can, to say that these crimes occur in this jurisdiction or that jurisdiction doesn't make sense. These crimes, defendants don't care about borders, and officers have to go out of their jurisdiction, out of their city, out of their county all the time. And to say that any time that they act outside the jurisdiction, that's a police power and so somehow you can suppress it, that's really a dangerous ruling in this case. And so I would just ask your honors to consider that when you're deliberating this.
Let me ask you, what's your best argument that suppression is not the appropriate remedy here?
I think the best argument is that, first of all, it's not a constitutional violation. There's no search here. There's no seizure here. There's no Fifth Amendment issue here. Second,
you saw the amicus brief about all the situations in which even in federal court they have suppressed when it was a state rule that was violated.
Right, and it was a wiretapping, right?
Right.
Yeah, wiretapping is a search.
Several of them had to do with wiretapping. There was one other too, but go ahead.
Yeah, those are, even though it may not have risen to a constitutional violation, that's still a search case. And if you look at all of these cases that we have, and I can name them for Miller, Ross, Rowe, not Sodders.
Sodders, there was suppression. You're
Yeah.
saying that we don't have to.
No, all of those cases are Fourth Amendment issues. They're search or seizure issues. None of these cases are an officer just acting, doing kind of regular police work. These are impinges upon the defendant's rights, and that's not what happened in this case. And so I think the first is constitutional, and then the second is what injury did the defendant sustain in this? And is it really worth, giving this guy a get out of jail free card, when he wasn't injured? Unless there's any other questions.
You were, I don't want to say grimacing, but every time you're prepared to make a point, we were interrupting you with questions. Would you like 60 seconds to wrap up?
That was Justice Byers gave me a segue into it about how, where does the line end between exercising police authority and just being on duty doing police work. It's a very dangerous road, especially, it could cripple investigations in Kansas if that's how far it
And
went.
explain to me again why that's our problem and not the legislature's problem.
Well, I think that this court,
I know you said reasonable, but you're going beyond reasonable. You want us to stretch the statute and read into it that which is not reasonably contained in the language.
Well, I would first note that Vrabel has been stretching the statute too. They suggest the distinction between a couple of these cases because, there's an emergency in those cases. That's why it was okay for them to affirm it. Well, there's no emergency exception here. Where does that come from? Second, I think that this court has a duty to uphold the Constitution and to protect Kansans. In doing so, you have to look at this in a reasonable manner and consider what was the legislature thinking when they created this rule. What was the reason for this statute?
If they were thinking that every governing body of every city should have the ability to control those persons that are performing law enforcement duties or the police powers within its borders, then why wouldn't that encompass having a neighboring jurisdiction set up a drug buy in your city? If the governing body didn't want drug buys in this parking lot, why wouldn't that fit the legislative intent?
Because
or the legislative policy.
Well, if that's the reason, if it keeps police officers from coming to another jurisdiction, keeps Prairie Village officers from coming to another jurisdiction, Leawood, to do these drug buys, so it allows Leawood to control their border, so to speak. That's what happened in this case. Prairie Village called Leawood, and Leawood was given a chance to say, no, you don't do that. I mean, obviously that doesn't happen because they're all in the same fight together to stop drugs being distributed in Kansas City.
So the cases that we have that say acquiescence is not the same as a request for assistance, that's where the unreasonable interpretation should be, that we should interpret the language asking for assistance or request for assistance to also encompass acquiescence.
Well, either that or in this case, there was a protocol set up. They had a system in Johnson County for dealing with these things. And that system was contacting the other jurisdictions and notifying them. And so it's dealt with. That issue is dealt with.
Is that in the record that there was this agreement in this system?
Yeah.
I know there was both officers testified.
Right.
One of them testified, I know who to contact in each of the cities, and gave some names of the people that he talked to in the various cities. But that falls a little short of saying that we had this agreement. We had this agreement, or we had this system.
Your Honor, I think that there's a couple of other places, but I'll point you to, let me get the volume number. Volume 5, which is October 1st, 2012 hearing. And I have in my notes, page 6, it says the normal protocol is to contact the other police agency and notify them that we're coming to his city for a narcotics investigation. Those are my words, so I don't know what exactly it says. Those are just my notes on there. But there's other places where on volume 4 on page 6 and looks like 7, it might be 6 through 9, I'm not sure. Kevin Cawley, who was the Leawood detective or whatever that handled the calls, testifies. So, yeah.
Yes, there is somewhere in the record that there exists an agreement rather than just reference to that's the protocol. I think there's a distinction between that.
Really? I don't think
protocol and agreement. Well, you inferred that there's some sort of agreement, a written or maybe not written, but an understanding that this is what happened.
I don't see the distinction between a protocol, which is an agreement between two people on how to deal with a certain situation, is different than a protocol.
Any more questions? Thank you, counsel.
Thank you, Your Honors.
You reserve 3 minutes for rebuttal.
Thank you. I just want to follow up on this, what we've been talking about. Assuming for the sake of argument there's an agreement. You can't have an agreement to violate a statute. The statute has a specific exception that the Court of Appeals found, and they're concurring that this was a request for assistance/help. The police officers have to follow that. They're not in, the plain language of this says, they're requesting, Leewood, I need help. In these cases that are cited in all the briefs, it's evident from the fact patterns that one could look at them and say, we need help here. Now, whether or not they actually, need it or not, they're chasing someone into a jurisdiction. And then they call, in that Brown case, which is unpublished, they call and they say, hey, look, we're following a drunk driver. Well, you could see, hey, we got to help out here. Something's going on. This is not an investigation, as it's been termed. This is staging a crime in someone else's jurisdiction. You're not investigating anything. You're staging something. And
do you think that investigations, under your view of the law, would a Prairie Village police officer be prohibited from driving to Wichita to interview a witness? Is that prohibited by the law?
Absolutely not.
And why not?
Because a private citizen can drive up and they can say, look, would you talk to me? And this happens on numerous occasions. But once you say, and if you don't talk to me, I'm going to put you in a 20-hour hold, then you better go get the local authorities.
So your view would be that Prairie Village police officer would be acting as a private citizen if they did that?
Absolutely. And I think they can do the same things as a private citizen up to the point where they start, exercising their police powers, holding people, detaining people, staging buys. So I would just, I'd really encourage the court to follow the law and let these people in Johnson County that are doing this under the best of intentions know that there's a law and it's there and they got to follow it just like everybody else. Thank you.
I've got a question here. Opposing counsel posed the question, what injury did defendant sustain in this instance? Do you have an answer to that?
I do. He sustained an injury of being taken to a place and charged with a crime unlawfully because they gathered evidence from him. That's, which they shouldn't have been able to gather in the form they did.
Well, okay.
So
how was he prejudiced if there was a parking lot across the street that had been in Prairie Village? What's the difference in the location? How did that make any difference to him, whether it was in Leewood or Prairie Village, the parking lot?
Right. I would have a tough time arguing that if it would have been set up there, but there could be hypotheticals because he may have said, I'm not going to dig that deep into that territory. This particular parking lot you can get and go. So he might have been prejudiced by virtue of the very fact he said, guess what, I'm not coming over there. So
that he wouldn't have gone.
He would have even gone
into Prairie Village.
Yes, that's one potential because of the way this particular geographic area lays out.
I'd like to go back to this request for assistance issue. And as I read the statute, it's subsection 2B, and it says you may go in any other place when a request for assistance has been made by law enforcement officers from that place. So was there who initiated the call between the cities here?
Well, Prairie Village initiated the call. So I agree with you. There was no request from Leewood.
That was my question. Is there any evidence to suggest that there was a request by Leewood at any time? We know that the call was initiated by Prairie Village.
Yes, and I agree, Your Honor. I don't think there's any evidence to suggest in this whole case that Leewood made a request for them for assistance.
All right, thank you. Any further questions?
But you don't dispute that Leewood acquiesced, that they were provided notice and did not object, and one could say they acquiesced in Prairie Village actions.
There's evidence to suggest that. When I cross-examined the officer, there were no police reports. He had no independent recollection.
Right.
But there's evidence to suggest that happened.
All right, thank you, counsel.
Thank you,
Thank you
Your Honor.
both for your arguments this morning. Court will take this matter under advisement.